Good morning. I'm Aaron Ginsberg with Community Teamwork's Fair Housing Program. Welcome to this morning's training on assistance animals. The work that provided the basis for this publication was supported by funding under a grant with the U.S. Department of Housing and Urban Development. The substance and findings of the work are dedicated to the public. The author and publishers are solely responsible for the accuracy of the statements and interpretations contained in this publication. Such interpretations do not necessarily reflect the views of the federal government. So, what is an assistance animal? First, let me say this training is for tenants. This training is for housing providers like landlords or property managers, and it is also for social service providers that are community advocates. Assistance animals help ameliorate or reduce the effects of a person's impairment, and that in turn allows them to engage in their life activities, whether it's in the house or otherwise. Assistance animals are really defined broadly under the Fair Housing Act. They are defined more broadly than under the Americans with Disabilities Act or the Rehabilitation Act. Service animals, emotional support animals, and animals that are not just dogs or miniature horses can all be assistance animals under the Fair Housing Act or related state laws. People with disabilities have a right to an assistance animal if it's necessary for them to engage in their major life activities, the things that other people without disabilities do and take for granted. The right to assistance animal is part of the rights to a reasonable accommodation. When I think about reasonable accommodations, the ones that most often come to mind are preferential parking if you have a mobility impairment. It could be paying your rent on the 7th if you receive Social Security disability. And the big one out there is the right to have an assistance animal. Reasonable accommodations, and I'm going to read this one. Reasonable accommodations are changes in rules, policies, practices, or services when such an accommodation may be necessary to afford such person equal opportunity to use and enjoy a dwelling. This standard is really similar to everything that you see under the ADA or the Rehabilitation Act. So what does it mean? What does that mean to have a right to a reasonable accommodation? How do I know if I have that right? Or how do I know if somebody has that right when they ask me for it? It's a three-part test. Does the person have an impairment? And is there a connection between the impairment and the request they're making? Both of these steps are the tenant's burden to show. And then once they've made that initial threshold, you get to step 3. And this is really the default, is that it is reasonable, but it's an opportunity for the housing provider to say, you know what, this actually isn't reasonable, and here's why. So how do you implement this? What happens when you say, I need to ask for reasonable accommodation? How do we work through the test to know if I'm entitled to one? It's called the interactive process. And I really like calling it the interactive process. This is what a lot of people call it. And it's a good term because it really encourages parties to share information freely. It's supposed to be an efficient process. It should be one that doesn't have these unreasonable delays. It shouldn't be intensely burdensome. Really, what we want is the tenant and the housing provider to be able to talk, exchange information, and reach an understanding that's going to work for everybody, particularly one that'll work for the tenant. So there are no magic words. You do not have to say reasonable accommodation. You do not have to call it an assistance animal. You can do it in writing. You can do it orally. You don't have to do it on a special form. Large housing providers often have their own policies and procedures for reasonable accommodations, and they have their own forms that they like to use. And that's great. It helps them make sure they're doing the process the way they're supposed to do it. And it makes sure that if they have multiple staff, that those staff are all doing it the same way. So if you can use those forms, that's great. But there's no obligation to. And if you need to use your own way or ask it orally, housing providers, you can just take that request, fill out your own form, and staple them together and move on to analyzing whether you need to grant the accommodation or not. Then the next step is it's the housing provider's turn to respond. Again, no unreasonable delays. If you delay too long, it's really effectively a denial because you're not letting the person have the animal that they need. You can ask about the effects of somebody's impairment, and you can also ask how it's connected to the accommodation they're asking for. but only do this if it is not obvious. If you have a tenant that is blind and uses a seeing eye dog, that is not a situation you should be asking for verification from a physician or a clinician. If it's not obvious, go ahead and ask. Some animals alert for seizures. And if your tenant has never had a seizure in front of you and that animal's never alerted to the seizure in front of you, you will have no way of knowing that this is a service animal. This happens a lot with assistance animals for emotional support. It is not mental health impairments. Behavioral health issues are not always obvious, and you can't always tell that the animal is really there to provide support. Nobody should ask a tenant for medical records. You should not be asked for medical records if you are a tenant. And the same with the doctor. You can't really insist that it is a MD that provides the support. It's a knowledgeable person that provides the support, a clinician that provides the support. While we're talking about this, I should say there's no obligation that a tenant provides that support letter when they ask for the reasonable accommodation. The idea is if the accommodation is for a obvious impairment and the connection's obvious, they shouldn't have to provide any support. So if you're going to accept an accommodation without that support, that's fine. If you need that support, then you can ask for it, but you shouldn't deny a application before you've had a chance to do this interactive process just because they haven't put in that support letter yet. It takes time to do a support letter. If they don't need to get it, it's easier for them. It's easier for the provider, the health provider. And then you can answer, is it reasonable? And there's really narrow exceptions, especially with assistance animals. The three categories of not reasonable is if there's a administrative burden or a financial burden, if there is a fundamental alteration to the way you operate your housing program, or if there's a direct threat. Most action around assistance animals comes with like a direct threat, especially if it's a dangerous breed. But understand that any of these inquiries need to be done on a individualized basis. You can't use a generalization or a stereotype about a breed or a size or a type of animal. You really need to look at that animal itself. So tenants, if you have a dangerous breed that is your assistance animal, you're probably going to get questions about that. If you can go out ahead and get your vet to say, hey, I've examined this animal. This animal is a safe, non-dangerous animal that is not aggressive, go ahead and do that. That's one step out of the way. If you're a housing provider, you might want to ask that if somebody is showing up with a dangerous breed that, scares other people, you need to make sure that that is a safe animal. But you can't reject it just because it is, a pit bull or some other animal. That said, there are some housing providers say things like it's a administrative burden or a financial burden because I can't get insurance, my carrier won't carry me. If you're going to make an argument like that, housing providers, I really hope that you've gone out and you've contacted other insurers, found out what those rates are, found out how they're impacting, your profits on the property. Make sure that you've said, hey, this is for an assistance animal. Do you guys do exceptions that way? You're going to want to document all of those things if you're going to reject an animal for an administrative or financial burden based on insurance. The doctor or knowledgeable person's letter. This is an important step in the process to talk about. When a tenant needs to get a letter that supports the existence of their impairment and the connection of that impairment to the request they're asking, it's most often done through this letter, and this letter can be extremely important. The quality of the letter can be extremely important. It makes a good letter, makes it easier for the tenant, and it makes it easier for the housing provider to assess and resolve an accommodation request. So I like to instruct folks to do it in really sort of like 3 steps. It doesn't have to be long, but it does have to be thoughtful. Providers should start by just providing their credentials. I graduated from this program and I've been practicing in this capacity for 25 years. The last 17 years, I've been at ABC Therapy and I've been working with my client for 3 years regularly and know him or her well. And then you can provide a detailed explanation of the effects of the impairment. Oh, my client has PTSD and anxiety related to a past trauma. It makes it really hard for her to sleep. It makes it really hard for him to be alone. It makes it really hard for them to eat or interact with other people. And I have found I prescribed an assistance animal. And this assistance animal is really important to the person. You have a no pets policy, and I really encourage you need to make an exception to this no pets policy because this person needs to have this assistance animal to help with their disability. It relieves their anxiety to an extent so significant that they can start participating in daily life activities that you and I take for granted. A simple letter like that, but one that explains it, identifies the impairment, identifies the connection. That's sort of the gold standard and is going to be easiest for a housing provider to say, yes, I understand, I can grant this accommodation now. The last slide that I have here that I want to talk about is, what is covered housing and who has to apply? The default rule here is that all housing is covered, and then we carve out a couple exceptions. And for people with disabilities, the federal carve-out exception is owner-occupied 4-family units or fewer. In Massachusetts, that is owner-occupied 2-family housing or fewer. So really, unless you are the owner and you live in one of the 2 units in your building, you need to be following the Fair Housing Act, and you need to be granting reasonable accommodations and requests for assistance animals when they are made to you. I've used the term housing provider. What does housing provider mean? It's really supposed to capture a broad group of people that provide housing assistance and services. For assistance animals, most often those people are landlords, property managers, condo boards, or homeowner associations. The last thing I have to talk about, I'm just going to review a little bit of resources that we have. This is how you get in touch with our Fair Housing program. You can reach us by email, you can reach us by phone, and you can do an online request for assistance if you feel like you're being discriminated against. We do have a complaint service. We can do information and resources. We can provide technical assistance if you need help asking for that assistance animal or help working with your provider to get a letter. We can do those steps and help walk you through it. And we can also give you referrals to HUD or a legal services organization if you are being denied that accommodation or you have a different fair housing issue that you aren't able to resolve without help. In Massachusetts, we've got some great legal service organizations. Some of them are legal service corporations like Legal Aid. They do a lot of eviction work. They do a lot of consumer issues. They do domestic violence issues. You can connect to them up here and find your one by region. We have other subject matter specific legal aid organizations like the Disability Law Center. You can find a whole list of them at the second link. There's some court information here, and there are also links to filing a complaint with HUD or under our state law with the Massachusetts Commission Against Discrimination. Here are some basic advocacy materials on reasonable accommodations and disability discrimination in housing. There's a HUD overview. There's some guides from the Bazelon Center for Mental Health Law, Disability Law Center's Emotional Support Animals and Reasonable Accommodations Guides, and then a couple examples of doctor's letters. These are a little bit longer than what I described earlier, but they are fabulous letters that also that you can hand to a housing provider and say, this is sort of the gold standard. This is what I need my accommodation letter to look like. Here are some joint materials by HUD and DOJ on reasonable accommodations. These are very accurate for housing, and you can use them in public accommodations. There's one just on assistance animals for HUD. And these are great to hand to housing providers, or great if you are a housing provider or a person that you want to learn more about what the process looks like, what the best practices are, and really how to get it right and understand everybody's obligations. I highly recommend this guide. And then here, stay connected. You can sign up for trainings on our website. We've got a number coming up all the time. And you can also sign up for our tenant or housing provider listservs. These are not going to flood your inbox. We do one a month. It gives examples of education materials for fair housing and also opportunities for trainings and other events. Well, I thank you. Again, my name is Aaron Ginsberg. I'm with the Fair Housing Program at Community Teamwork, and you can visit our website or HUD or a number of other great places to learn more about reasonable accommodations. Thank you.